All right, everyone. So we are going to begin the program now. So first of all, I want to say thank you for everyone for coming. Realize that this was originally scheduled for Tuesday, but in light of the snow day, we had to move it to today. So thank you guys for being flexible with your schedules and making it. In line with the snow day, so I received.
Just so everyone could read the opinion. I did that like that night, Monday night, so I was ready to go, but.
It kind of,
as we all know, DC can't handle snow, so.
It did coincide perfectly, I would say, with the ruling out of Brownsville. So that gives another inflection point for this event. So the way things will work today is we will give each speaker up to 15 minutes to give their opening remarks. Then we'll go down the line if anyone has any additional comments, and then we will turn it over to you guys for questions and answers. So feel free to come up with any questions, and we'll have microphones running around. So first, I will introduce our first speaker, David Rivkin. David is partner at Baker Hostetler. David is a member of the firm's litigation, international, and environmental teams, and is co-leader of the firm's national appellate practice. He has extensive experience in constitutional, administrative, and international law litigation, and has been involved in numerous high-profile cases. David also has a great deal of experience in the public sector, having served in the administrations of both Presidents Reagan and Bush 41, where he developed and implemented legislative, regulatory, and litigation initiatives. Over the years, David has been published in hundreds of articles, op-eds, book reviews, and book chapters on a variety of international, legal, constitutional, defense, arms control, foreign policy, environment, and of course, immigration issues, and has been published in various newspapers and magazines, including the Wall Street Journal, the Washington Post, the New York Times, USA Today, Los Angeles Times, and many more. He's also a frequent commentator and guest on TV and radio shows, including ABC, CBS, NBC, CNN, Fox News, NPR, and PBS. After David, we will have Kamal Saheb. He is immigration policy attorney at the National Immigration Law Center. Kamal engages in advocacy and technical assistance relating to state and local enforcement of immigration law and access to legal status for immigrants. At NILC, his advocacy is focused on the passage of the DREAM Act, the implementation of the Deferred Action for Childhood Arrivals program, and state and local enforcement of immigration law. Prior to joining NILC, Kamal was practicing an immigration attorney at CUNY Citizenship Now, a nonprofit immigration legal services provider in New York City. Kamal is an immigrant from Morocco and is fluent in Arabic. And our final speaker will be Ilya Shapiro. Ilya is a senior fellow in constitutional studies at the Cato Institute. He's also the editor-in-chief of the Cato Supreme Court Review and serves as coordinator for Cato's amicus brief program, which has filed more than 100 amicus briefs in the Supreme Court. Before joining Cato, he was a special assistant and advisor to the multinational force in Iraq on rule of law issues and practiced international, political, commercial, and antitrust litigation at Patton Boggs. Ilya has provided testimony for Congress and state legislatures across the country and has contributed to a wide variety of academic, popular, and professional publications, including the Wall Street Journal, the Harvard Journal of Law and Public Policy, the Los Angeles Times, USA Today, and the Weekly Standard. He's also a regular commentator on the news and other various media outlets, including CNN, Fox News, ABC, CBS, NBC, the Colbert Report.
All the ones listed for David, plus the Colbert Report.
Plus the Colbert Report. So without any further ado, I will turn it over to David, and I'll be back for questions.
Thank you. Well, I am licked on the Colbert Report, I guess. Thank you for a rousing introduction. Makes me feel venerable, both good and bad way. But more seriously, I wanted to thank the Federalist Society for sponsoring this important debate. I look forward to sparring with my colleagues, and to the extent we're unlikely to agree, I at least hope to elucidate for all of you the points of agreement and disagreement. Let me begin with a brief disclaimer. I'm planning to focus solely on the legal merits, or more precisely, lack thereof, of the President's immigration initiative. I'm not going to wade into the policy merits of what he is trying to do, nor do I want particularly to get into the question of whether the pre-existing immigration regime, based upon duly enacted statute, Immigration Naturalization Act, or INA, in abbreviated form, is sound or dysfunctional or even broken. This is for very obvious reasons that, thinking as a lawyer and a constitutional lawyer in particular, the policy merits of a given statute are utterly irrelevant to the question of whether or not the president's rewrite of said statute is appropriate from a constitutional perspective. And as for the point about immigration law regime based upon INA being incoherent, at the risk of sounding flippant, I would tell you, having practiced in this area both in and out of government of administrative law, most components of a modern administrative state are dysfunctional and broken. It's kind of an ugly edifice. If it went by that, then the president would have unbridled authority to do pretty much whatever he wants, because most of the congressional creations, I speak as somebody who participated in my day in drafting several major statutes, including a little guilty confession, Americans with Disabilities Act, and do not work very well. Now, let me also say that I'm going to give a fairly short shrift to the argument that advanced, among others, by my good friend Ilya, not this Ilya, but Ilya Shapiro, and some others, that, oh, poor president, Congress has enacted so many laws that it is impossible to faithfully execute them all, so the president must target for compliance some subset thereof and let the others lie under-enforce. This doesn't mean that I don't share the pain of my libertarian friends. The administrative state, as you surmise from my previous sentence, has indeed grown, and in a fairly dysfunctional fashion. And I'm certainly unhappy with the criminalization of many things at the federal level. But this regrettable phenomenon, again, does not provide any basis for the president to exercise what the framers would call either suspending power, which is suspending the implementation of a given statute entirely, or dispensing power, which is suspending the implementation of a statute with regard to certain categories of individuals and entities. But please don't take my word for it. What matters is that the Supreme Court of the United States confronted this very question in 1848, whether the president can exercise dispensing or suspension power. The case was called Cato versus United States, and there the president's lawyers, unlike in a very forthright manner, unlike the lawyers for the president in this administration, have made essentially the same argument that some of my libertarian friends are making. Remember, it was 1848, but the argument was that Congress passed too many statutes. We don't have the resources to implement it all, so it's kind of an elegant twist. Since we cannot faithfully execute all of them at the same time, the best way to comply with a faithful execution obligation, ladies and gentlemen, is to execute a subset of those statutes and let others lie under enforce. The Supreme Court did not buy this argument, calling it the suspending or dispensing power utterly alien to our constitutional tradition. Now, this controversy, by the way, a brief foray into history, did not originate in 1848. Dates the much older confrontation between King James II and the Parliament, which eventually culminated in the Glorious Revolution. And an interesting footnote here, since, of course, we hear about the dysfunctional nature of INA. What was in play there is that King James refused to enforce numerous parliamentary statutes that blatantly, rather viciously discriminate against Catholics. So from a moral perspective, he had a very strong claim. From a legal perspective, he had no claim at all, because the Parliament understood perfectly well that if a king can exercise suspending or dispensing power, there's nothing left for the Parliament. The king has absolute power in his hands, and as far as judicial review is concerned, what's there to review? Review and exercise of absolute power is not a very fruitful proposition, although I suppose there is something called the Administrative Procedures Act that may discipline them. I'm being facetious, at least from the procedural perspective. So the court's ruling in Kendall reflected those far more fundamental problem of the suspension and dispensing power. Let me briefly muse about the faithful execution language, which we all know about and is frequently bandied about, but to reflect on it briefly, there are only two places in the Constitution, ladies and gentlemen. One is full faith and credit clause, and another one is faithful execution, that imply some element of scienter. There's no scienter in other things. Look at what's on Article 1 or Article 2, enumerations of power, Bill of Rights. Why is it there? Now, the framers believed that both horizontal and vertical separation of powers are going to be preserved in many ways, but primarily for ambition counteracting ambition, et cetera, et cetera. But they're clearly recognized there would be some circumstances where it would not work. Because what do we have with regard to faithful execution? This is Article 2 carrying the water for Article 1, because Article 1 really is not involved in the execution of laws. With regard to the states, what does the full faith and credit clause mean? It means that state A carries out the order for state B. And in those circumstances, you cannot rely on the sort of a common self-interest that otherwise framers believe animates human behavior and would be a nice backbone for separation of powers. So the faithful exercise, faithful execution and full faith and credit clause are very important glue to make the separation of powers work in those two unique sets of circumstances. So the Kendall court, in my opinion, was absolutely right in rejecting the president's claim that I cannot execute all the laws faithfully, so let me execute some laws faithfully. And again, I don't think I need to elaborate that it would be a disaster for individual liberty if that view were to hold. Now, let me spend the balance of my time, I don't have much time, in describing, and based upon actually an op-ed piece I've done in the Wall Street Journal some weeks ago with Professor Elizabeth Foley as to why this is not an exercise of enforcement discretion, not an exercise, it being President's immigration initiatives, and not something that can be justified by resource constraints, but is a classical exercise of dispensing power. And to do that, I'm going to briefly walk through the OLC opinion that the administration secured. My guess, reading it, it was written rather quickly, and we can talk a little bit more about parsing it, but basically was released very shortly before the initiatives were announced, literally a few hours. So there are 5 basic arguments that OLC advances, all of which, in my opinion, fail. So first is they justified what is being done as prioritization of government's limited resources, but that's self-evidently false. Because if you look at what the initiatives are, it is basically a rewriting of existing parameters for deportation. Now, illegal immigrants would not be deported unless they're a threat to national security, public safety, or border security. Beyond those 3 categories, deportation can be pursued only if, they quote, would serve an important federal interest, close quote. But under duly enacted INA, by contrast, whoever enters the country illegally is a deportable alien who shall, and quotes, upon the order of Attorney General, be removed. So the President's policy transforms an entire category of aliens who otherwise are deemed deportable because they entered here illegally or overstayed their original visa parameters into 2 different categories, one which is deportable and one is not. This is a shift in kind, not a degree, and the President, prioritizing enforcement resources, would have done what presidents have done, which is enforce the entirety of immigration law, but focusing resources in particular on the highest categories, most, let's say, those categories of illegal aliens that whose justification for their removal would be the highest. So now, the second part, which is really at the key of this, is OLC claims, rather disingenuously, and I love our office, having worked with it for many years when I was in the White House counsel's office. I think it's just depressing how disingenuous this position is. So OLC position is that this is an exercise of case-by-case discretion. Now, why is it important? As OLC properly admits, and I quote, a general policy of non-enforcement that forecloses the exercise of case-by-case discretion poses special risks that the agency has exceeded the bounds of its enforcement discretion. Now, that's the case in part because of a Kendall decision that I referred to, but more fundamentally because an across-the-board non-enforcement of the law with regard to categories of people is what, ladies and gentlemen? It is dispensing power. That's what it is. So it has to be case by case. And there's, by the way, a leading case, aside from Kendall, that makes this point is a case called Cheney that OLC opinion parses at great length. OLC is right about this having to be case-by-case discretion exercise. They're wrong as to how they apply the facts. So OLC basically says, look, there is no categorical bar for removing anybody. The ICE, just a new nickname, used to be called INS, the ICE field directors, about 65 of them, who will be processing those applications, would have discretion not to approve any given application. But the theoretical possibility that a small percentage of a 4+ million applicants would be rejected does not a case-by-case discretion make. The absurdity of his argument is demonstrated by one example, a very recent example in this administration called the 2012 Deferred Action for Childhood Arrivals, DACA. Of the roughly 521,000 DACA applications considered on a case-by-case basis, less than 3% have been rejected. The approval rate of 98%, any notion of a case-by-case discretion falls flat. You get rubber stamps here. But also, ponder for a second, what is the context here? Unlike situations in consular offices where you go to an embassy and you want to get a passport and you qualify on paper, you show your return tickets, you show a bank account, so you may get back to your home country. But you're sweating, you look shifty. So the consular officer, because there's no duty to approve, there's no right to come here, would reject you. Would 65 ICE field officers be scrutinizing personal veracity or just appearance for people? No, they're going to get 4+ million applications and be processing them furiously to the tune of hundreds, if not thousands a day. So the whole context for how this would work does not provide for any discretion. Third, even if you assume that this was an exercise of case-by-case discretion, which it does not, it is not. It created a remedy, deferred deportation, for a category that Congress has not authorized. Now, OOC goes for history and lumps together deferred deportation with other kinds of deportation relief. I hate to be technical, but it's important, like parole, temporarily protected status, and deferred enforced departure. But all those categories, ladies and gentlemen, have come into being because of specific authorization by Congress, or in the case of enforced departure, the President's independent foreign affairs power. By the way, one thing about the OLC opinion that I like, it rejects the notion that the President has inherent constitutional authority to defer deportation across the board. To be sure, for those of us who are familiar with the teaching of Youngstown, the notion that because of the President's foreign affairs power, he can do something that's inherently domestic in a situation where Congress has written a statute of the contrary would not hold that much water. What matters here for us to appreciate is Congress did indeed authorize deferred deportation for specific categories. It has not authorized it to those who President Obama wishes to extend it, which are parents of U.S. citizens and lawful permanent residents. I'll briefly say, since I'm sure it's going to come up, that even if, because OLC claims, even if there is no explicit statutory authorization, there's no constitutional basis for it, there's case law that supports it somehow become embedded in our legal system. Not clear how outside of a very limited area of federal common law a court can create something like this, but even that aside, the case they're relying for, which is the 1999 Supreme Court case called Reno versus American Arab Anti-Discrimination Committee, is flat out wrong. In that case, members of the Palestine Liberation Front asserted that INS refusal to defer the deportation constituted discrimination. The court disagreed, never reached the merits because they're saying that the statute that gave INS power in this area, we got the very limited category of people, specifically withdrew a possibility for judicial review. So the court, in that case, merely said, you're not entitled to judicial review. It never said anything about the merits of the decision. Now, OLC claims that Congress has acquiesced to defer deportation, again, describing various instances where Congress has done it, but different categories. And again, for somebody who practices administrative law, the notion that because a statute creates some, and this is probably not enforcement discretion at all, this is an administrative discretion. So a statute creates discretion to do A, B, and C, and you're going to infer from it that the statute also creates discretion to do D? That's kind of laughable. If I try to make this argument in the D.C. Circuit, I would not get beyond 30 seconds of my peroration. Now, fourth, and I'll come to a close, OOC claims that past presidents have taken similar actions. Not true, they're only superficially similar. They've taken actions, again, based in the context of specific congressional authorization. Their primary example is something called 1990 Family Fairness Policy, FPP, of President George W. Bush, which I actually have some personal experience with, that affected estimated 1.5 million people, a large number to be sure, children and spouses of those granted amnesty by the '86 Immigration Reform and Control Act. But FPP, ladies and gentlemen, was exactly consonant with existing statute, and FPP did not grant deferred deportation, but a deferred voluntary departure for up for 1 year. That is, again, may sound pedantic, but that is a huge difference. One final point. What OC also totally ignores is the fact that this decision violates vertical separation of powers, which is to say federalism. We all know about the lawsuit championed by Texas and 25 other states. We can discuss the PI decision, the question and answer period. But the states have argued correctly that it's going to cost them money, driver's licenses and such. But there's even a more fundamental reason why it violates federalism. Let me put it this way. In our constitutional system, all states live in a shadow of a supremacy clause, which means that the police power is always cabined by instances where the federal government, Article 1 in particular, exercising its limited enumerated powers, creates a preemptive statute. It can be conflict preemption, or it can be field preemption. Field preemption means the entire chunk of police power at the state level can no longer be exercised. Now, what does it mean in case of INA? In a case called Arizona versus United States, decided a couple of terms ago, the Supreme Court told us that INA is a preemptive statute, and therefore it struck down certain provisions of something called SB 1080, which is a statute passed by Arizona. But what is a preemptive statute, ladies and gentlemen? A statute as passed by Congress in accordance with proper constitutional procedures. The President participates in this exercise, but it's fundamentally an Article 1 driven exercise. Now we have a statute rewritten by the President that has the same preemptive force. So you have an improper preemption of state police power. It's actually very, very fundamental, and I'll close at this point. It goes to the very heart of a constitutional bargain. Why did the 13 states and the citizens of the 13 states who ratified the Constitution agree to live in the shadow of a supremacy clause? Because, ladies and gentlemen, they were given a set of tools to ensure that federal legislation that preempts is something in which they participate, primarily through the fact that every state has equal representation in the Senate. So they can delay it, they can structure it, they can impact it. None of those tools are relevant if a president writes his own statutes. So what is being done here, not to be too highfalutin, is not even about immigration and suspension power, but it is about that for sure. It is about a fundamental warping of our constitutional bargain and emasculation of the states. Thank you for your time.
Thank you, David, and good afternoon, everybody. Thank you to the Federalist Society for Law and Policy for inviting me to participate on this panel today. My name is Kamal Saheb, and I'm a policy attorney at an organization called the National Immigration Law Center. We're an organization that is committed to advancing the rights and opportunities of low-income immigrants. 3 months ago, President Obama announced policy changes that we feel bring much-needed order, humanity, and transparency to our dysfunctional immigration system. The President's executive actions on immigration amount, we think, to critical immigration policy directives at bringing about fairness and accountability to a system that badly needs it. Although the plan, as announced by the President on November 20, 2014, is comprehensive in that it establishes interior and border enforcement priorities, creates opportunities for investors to remain in the U.S., and other policy changes, much of the public debate has focused on the deferred action for parents of Americans and deferred action for childhood arrivals processes. A little bit of background under the new DAPA process, deferred action for parents of Americans. Individuals who have been residing in the U.S. since January 1st, 2010, and who could establish that they have children who are U.S. citizens or permanent residents will be able to come forward and apply for something called deferred action. And this deferred action, which was referred in the prior presentation, is a designation for individuals that says that they are low priority for immigration enforcement. And after an adjudication that's conducted on a case-by-case basis, and that includes fraud and national security and background checks, the Department of Homeland Security determines that the individual, if the individual merits, A, meets the criteria, and B, merits a favorable exercise of discretion, they can further apply for a work permit if they jump through another hoop. They can show that they have an economic necessity for that work permit. So what's the legal authority behind this? So these deferred action processes, DACA, DAPA, are rooted in the doctrine of prosecutorial discretion, which provides DHS, as well as other federal, any law enforcement agencies, the authority to set enforcement priorities, essentially to target resources and shape how the law, any law, is implemented. This doctrine of prosecutorial discretion is well established with constitutional, legal, and historical grounds. First, it's well settled in the courts that executive officials have wide latitude in exercising prosecutorial discretion. As chief prosecutor, the president and his administration not only have a duty to enforce the laws, but also the authority in deciding how to do so. Every law enforcement agency, including the agencies that enforce immigration laws, have this prosecutorial discretion, the power to decide whom to investigate, detain, charge, arrest, prosecute. There's a great deal of agreement in the courts about the wide latitude executive officials have in determining whether to prosecute apparent violators of the law. Since the confiscation cases in the 19th century, the Supreme Court has been reluctant to permit courts to even review an agency's exercise of prosecutorial discretion. And more recently, in a seminal case called Heckler v. Cheney, Supreme Court held that an agency's decision to enforce or prosecute, including the decision to not prosecute, in either civil or criminal matter, is a matter of the agency's absolute discretion, noting that the agency was better equipped in handling that balancing of its own resources and interests. Similarly, in a case called Lincoln v. Vigil, the court explained that the allocation of funds from a lump sum appropriation is another administrative decision traditionally committed to agency discretion. The court has repeatedly affirmed this longstanding principle that the executive branch has virtually unfettered discretion in deciding how and whether to enforce the law against individuals. In the area of immigration enforcement, the power of deportation, which is a civil matter, has been treated similarly to a prosecutor's power to pursue criminal charges. The case of Reno versus AADC, which was referred to in the prior presentation, in that case, the Supreme Court stated that the concerns that make prosecutorial discretion, quote, ill-suited for judicial review are greatly magnified in the deportation context. So different contexts, similar concerns. The AADC court expressly referenced deferred action, which is the form of relief that the president is creating a process for applying for here. Expressly referenced deferred action as a long-standing agency practice, and noticed that the purpose of INA 242G, which is a provision in the Immigration Code that bars judicial review of certain agency actions, was in part to shield immigration authorities from judicial review of their decisions about whether to grant deferred action. Second, exercising prosecutorial discretion to prioritize the deportations of certain individuals is consistent with the Take Care Clause of the Constitution. Because the executive branch is rarely provided with enough funding to enforce every provision of every law against everyone, the executive branch must develop some enforcement priorities. The Take Care Clause of the Constitution states that the executive shall take care that the laws be faithfully executed. When evaluating whether this requirement has been met, courts ask if the executive has adopted a general policy which is in effect an abdication of its statutory duty. No court, however, has struck down an executive policy of non-enforcement on Take Care Clause grounds. Some commentators argue that the number of people who are affected by lack of enforcement is somehow a factor when determining if the executive's lack of enforcement is an abdication of statutory duty. For example, in Crane versus Napolitano, plaintiffs argued that an estimated 2 million individuals would be eligible for deferred action under a 2012 deferred action directive that covered Dreamers, and which they argued amounted to a decision by the executive not to enforce the INA for this group of people. So the question was whether that constituted an abdication of duty. However, in Heckler v. Cheney, a case I referenced earlier, the Supreme Court stated that faithful execution of the law does not necessarily entail acting against each technical violation of the law. Moreover, because the executive is rarely provided enough funding to enforce the law against all of whom the law could be enforced, the president performs, this I'm quoting the Cheney court, the president performs his full constitutional duty if the means and instruments provided by Congress and within the limitations prescribed by it, he uses his best endeavors to secure his faithful execution of the laws enacted. So we're in a situation here where there's a large gap between the number of people who could be removed based on existing resources, who could be removed based on the technical violations of the law, and the resources that are required to remove them. And that gap demonstrates, we think, the inherent necessity for the executive to develop immigration enforcement priorities. In fact, enforcement priorities in the context of immigration have been used for decades for this very reason. The president can continue to prioritize violent criminals or smuggling enterprises and still use all of the resources that Congress appropriates for immigration enforcement. Third, prosecutorial discretion to stop or suspend the deportation of immediate family members of U.S. citizens and lawful permanent residents is consistent with the INA. Under Heckler, prosecutorial discretion may be limited, quote, where the substantive statute has provided guidelines for the agency to follow in exercising its enforcement powers. However, the INA, the Immigration Code, does not require immigration officials to initiate removal proceedings against all individuals who are unlawfully present in the U.S. Section 103A of the INA expressly delegates to the Secretary of Homeland Security the, quote, administration and enforcement of the INA and all other laws relating to immigration and naturalization of aliens. Moreover, the Homeland Security Act of 2002, that's the act that established the Department of Homeland Security, expressly charged the Secretary of Homeland Security with the responsibility of, quote, establishing national immigration enforcement policies and priorities. In determining who to remove, DHS is clearly entitled to Chevron deference, which only requires an agency's reasonable interpretation of the statute. Under this level of deference, the executive's decision to stop or suspend deportations of these groups we think should be permissible. The president's executive actions are therefore simply a matter of statutory interpretation in accordance with the Homeland Security Act. Finally, there is ample historic precedent for the president's actions. Every administration, Republican and Democrat, since Dwight Eisenhower has exercised prosecutorial discretion to protect some subset of immigrants from deportation. Administrations have often granted relief to groups of individuals, including those who would benefit from potential legislation, or even those who were considered for relief by Congress and then explicitly denied that relief by Congress. For example, Family Fairness Policy, FFP, that former Immigration Natural Service adopted from 1987 to 1990, after the 1986 Immigration Reform and Control Act provided indefinite That policy provided indefinite voluntary departure to spouses and children of people who legalized under IRCA, the law passed by Congress in 1986, even though they themselves were left out by the statutory amnesty program signed into law by President Reagan. Critically, they were left out after Congress explicitly considered and declined including them in the legalization. In announcing an expansion of the program in 1990, then INS Commissioner McNary said, quote, "It is vital that we enforce the law against illegal entry. However, we can enforce the law humanely. To split families encourages further violations of the law as they reunite." The Family Fairness Program required individuals to apply affirmatively, just like the deferred action programs do, and included the creation of a new form, just like the new deferred action program does. Just months later, Congress did in fact enact the Immigration Act of 1990, which essentially codified the president's actions and granted protection from removal and employment authorization by statute. One could argue that the Family Fairness Policy serves as an important precedent for the programs we're talking about today. Lastly, I want to talk about why this is good public policy. President Obama's executive actions are not only legal, but they're good public policy. Not only will the president's action bring order and transparency to how DHS conducts immigration enforcement, it will add billions of dollars to our coffers. The U.S. spends now approximately $3.5 billion on immigration enforcement than it does on all other law enforcement activities combined. That includes FBI, that includes DEA, ATF, you name it, all other federal law enforcement activities. Immigrants are being deported in record numbers. More than 4 million people have been deported from the United States since 2001. with 2 million being deported under President Obama alone, more than any other presidency. The removal of these 2 million people is numerically equivalent to wiping out the entire combined populations of Boston, Miami, Seattle, and St. Louis. By creating a process for these individuals to come forward and apply, the government will be better able to focus its priorities instead of separating families. Not only will expanding deportation relief and work authorization bring millions of people out of the shadows, thereby enhancing national security, it will also inject positive growth in our local, state, and national economies. The executive actions will increase our GDP by an additional $210 billion, reduce the federal deficit by $25 billion, and raise the average wage for U.S. workers by nearly 0.5%. So, a little bit about the moral imperative for this. While the legal and historical grounds for executive action are very clear, the President, we feel, has the moral responsibility to act. Reasonable minds might disagree on the politics or whether this is good policy, but what is undeniable is that the status quo is just not acceptable. For example, significant numbers of U.S. citizen children are impacted by these record deportations. And data from the Department of Homeland Security reveals that 72,000 parents of U.S. citizens, 72,000 parents of U.S. citizen children were deported in 2013 alone. Children suffer immensely when a parent is arrested or deported, facing years of separation, decreased economic support, and social and psychological trauma. For some, the trauma of separation can have even more devastating consequences. As of 2011, about 5,000 children were living in our foster care system due to a parent's or both parents' deportation. So I'm going to conclude with what's next for DACA and DAPA. Where are we at? So as part of the President's announcement, the expansion of DACA program was set to begin this week. And the DAPA application process, so DACA is for childhood arrivals, DAPA is for parents of Americans, the DAPA program was scheduled to begin in May. NILC, our organization, and other advocates around the country have been working with community stakeholders and local, state, and federal policymakers, including the administration, to ensure that these programs are implemented fully, fairly, and effectively. But this implementation process suffered a setback earlier this week when a court in Texas, in the case of Texas versus the U.S., issued an order enjoining DHS, Department of Homeland Security, from rolling out the program. I want to make a couple of comments about what the decision did do and what the decision did not do. The court did not find the program unconstitutional. In fact, it merely found that the administration should have undertaken rulemaking under the APA, Administrative Procedures Act, to institute this deferred action process. That's what the court found. 2, the court did not dispute that DHS has broad authority to exercise prosecutorial discretion in determining whom to enforce the law and whom not to enforce the law against. In fact, it found the opposite. 3rd, the court rejected the state's argument and the argument that we've heard in media over the past few months that these deferred action initiatives would be a magnet for undocumented immigrants to their states. That somehow, if these individuals were to get deferred action, or if somehow this deferred action, because this deferred action program exists, that there would be an illegal immigration magnet, both to the U.S. in general and to specific states. The court found that speculative and baseless. The court did find standing for the states that we're suing based on Texas's claim that its issuance of driver's licenses to qualified individuals had a negative fiscal impact on the state based on the payment structure of the state's driver's license program. But the court ignored the various other benefits, and we could talk about that more in the Q&A, that driver's licenses bring to the states. This isn't the first time that a state has tried to stop one of President Obama's immigration actions. In 2012, Mississippi also sued in an attempt to block the original deferred action program as announced in 2012. And the state was dismissed, and the state's claim was dismissed for lack of standing because the court found that its asserted fiscal injury was baseless. This court's decision, this Texas court decision, was, we think, the first chapter of a very long book, and we at the National Immigration Law Center are confident that the programs will ultimately survive legal scrutiny. Implementation is inevitable and simply a matter of time. Thank you.
Well, thanks very much for having me. Thanks for coming to this very topical event. I know that a lot of you are here for the free lunch, so I hope you've been enjoying that. And secondarily, you're here for the excellent networking that all Federalist Society events provide. And we're here for your dining entertainment, and I'm happy to play my part in that role. I also won't talk too much about policy, although let me get my policy priors out of the way, and also my full disclosures out of the way. I filed a brief on behalf of Cato and two law professors, Peter Margulies and Josh Blackman, who all support comprehensive immigration reform and believe it should be done legally. So we supported Texas in this case. And I say this not just as a policy wonk, but as an immigrant myself, a double immigrant, in fact, as is David, for that matter. So this, you know, you can see that we're trying to be objective. In fact, like most immigrants, I do a job native-born Americans won't, defending the Constitution. So what really, on the policy front, offends me about this action is that it harms chances for real reform, which I'll get into at the end. Now, moving to the law, I'll start a little bit responding to some things that Kamal said, and then describe my views of the Judge Hannon's ruling and what we can expect going forward, so as not to overlap too much with what David said. I think most or all of his analysis I agree with. First, Kamal emphasized, as do all of the arguments for the government, prosecutorial discretion. It depends what you mean by discretion. Surely Congress couldn't pass a law saying you, prosecutor, executive, can do whatever you want in the area of X, immigration or anything else. Or for the terms of a year, you can do whatever you want. Or any other such, plenary sort of true, complete discretion. That would violate the separation of powers, the delegation doctrine. You can't just pass legislative authority along. So just calling this prosecutorial discretion begs the question of whether you're enforcing the law and making new law. And that's why Judge Hannon's order, and indeed the lawsuit itself, does not target at all the ability of the government to prioritize going after violent criminal drug gangs over people who violate no laws other than being in the country without legal status. That's a perfectly fine exercise of prosecutorial enforcement discretion. Might not be so wise as to formalize that into an official policy guidance or memo or instruction or direction. Typically, your local prosecutor isn't going to put out a memo saying, here's our ranking of offenses, murder, rape, robbery, burglary, all the way down to, jaywalking or whatever the case may be, a schedule. So you can weigh, any would-be criminal can weigh their risk-reward matrix based on what that particular prosecutor's resources and priorities might, again, that might be getting into semantics and questioning the wisdom of putting that. But again, this is not an attack on the discretion to enforce more violent, sex trafficking, all of that over, someone who's a gardener or a maid and is in the country illegally. This is purely about creating new sorts of benefits, granting new sorts of benefits, whether it be work permits, whether it be burdening the states with providing driver's licenses, welfare, and any other sorts of state benefits that are triggered by federal legalization of status, even of the temporary kind that this represents. And that's why Heckler versus Cheney is indeed important, that courts are not to review prosecutorial issues of prosecutorial discretion or enforcement, but what happens when there's complete abdication, a decision not to enforce the law wholesale, not just to distinguish between who to use, and indeed a creation of arguably new law, new programming, because at the end of the day, this deferred action is something new. I mean, deferred action itself isn't even in the statute and isn't even provided for in the immigration statutes, even on a case-by-case basis. Now, it's been implicitly relied upon by executives going back decades. including in some notable cases that have been described and that the OLC memo relies upon. And it's been implicitly acquiesced to by Congress in certain uses and ratified post hoc as well. But at the end of the day, what we're talking about is this kind of implied executive authority to determine who to move against and who not to move against being transmogrified into the provision of temporary work permits and all the benefits that that attach to them to a whole class of people, not on some temporary emergency basis, as all the categories, all the class-based categories have been used in the past. That is, these previous instances, there were 5 that were mentioned in the OLC memo, victims of domestic violence who, if they didn't leave their abuser, they would be out of status because their status was tied to him, victims of trafficking and other such things, refugee-type statuses, foreign students who were affected by Katrina. In all of these circumstances, there was an existing lawful status that person had, and what the executive action deferral was doing was providing a bridge to another lawful status. And if one of the T and U visa applicants, the sex trafficking victims, whatnot, was ultimately adjudged not to have a legal case, then they would have to leave. It's a bridge between statuses, not a tunnel under the immigration laws or a detour around what the law provides. And in each of these cases, there was an immediate prospect of lawful presence. And by the way, the OLC opinion doesn't even mention the family fairness actions of 1988, 89 that Kamal mentioned, because they sort of operated in a different way and had even less legal basis. None of these were challenged in court, by the way, so it's unclear whether they were legal to begin with. And just precedent of unconstitutional presidential action is not evidence that how did Scalia call it in the Noel Canning recess appointment case? Executive power by adverse possession. I think there might be a little bit of that going on here as well. And finally, at base, take a step back and see who are these people who are going to be eligible for at least temporary legal status under DAPA. Parents of U.S. citizens or even lawful permanent residents. Well, Congress considered giving eligibility to parents of citizens and lawful permanent residents and decided not to when they were writing the relevant laws. They said that we don't want to reverse birthright citizenship, but to deal with the potential for anchor babies, as it were, the child cannot petition for the parent until that child is 21 years old, and if the parent's been in the country for a year, they have to have left the country for 10 years. If they've been in the country for less than a year, it's 3 years. That 3 or 10-year bar is significant, and there was significant debate in Congress. I'm not talking about this most recent Congress, when the original INA was being put in. They wanted the incentives to be structured in a way so as not to make it easy for family unification or other such justifications that had been raised for DAPA as evidence of being consistent with congressional intent and acquiescence. Again, this is not a bridge between soon-to-be lawful statuses, but a tunnel or a detour around the existing law to create new legal status that Congress had otherwise rejected, which is why this exercise of executive power is at the nadir of executive power in the Youngstown rubric, the steel seizure case, Justice Jackson's famous delineation of executive power, and that its exercise is at its zenith when Congress has acted in accord with what the president is doing, and it's at its nadir when Congress has rejected the purported presidential action. And here, Congress, to its shame, rejected the DREAM Act. Congress, to its shame, has not passed comprehensive immigration reform, and so we're left with a system that benefits nobody except potentially immigration lawyers and bureaucrats, not big business or small business or the economy or national security or anyone, and Congress hasn't fixed it, and that's terrible. And I criticize Congress for that all the time, and I criticize the various special interests that put in poison pills when you're even trying to do less controversial reforms. But there is no, when Congress doesn't act for good, bad, or no reason, the president gets more power clause in the Constitution. At least not in mine. I use the Cato version. I don't know what y'all have. Okay, let's turn to the, I can go into about, if you want to read more about the kind of the constitutional issues, I really recommend Josh Blackman's work. He has an article posted on SSRN. I don't know if it's fully, published as it's, what's the difference between published and freely available in public. But anyway, on both statutory issues and on the constitutional issues, his analysis of the president's failure to take care and acting in bad faith. We all know the series of 22 or 23 times that the president said, I'm not a king, I can't make the law by myself, and then he changed his mind and crows the day or two after the executive action that I acted to change the law. Admits it and says it's a good thing. Anyway, I will, if you're interested in that, we can talk more, or you can read Josh's article. And it's just very quickly about Judge Hannon's ruling. First, this is not a political hack job. This is a 123-page thorough examination of all the arguments, nearly 60 pages on standing alone. This is not, a few pages accepting one side or another, or reaching out to take issues that weren't really there, as you can say about previous rulings that have taken up this action. The judge recognizes that his words will quickly already are being scrutinized by national decision makers and legal analysts. The standing discussion shows his judicial integrity. He talks about how there are real costs. All you need is $1 of damage to have standing, and here there are real costs per new applicant for a driver's license, as well as other state bureaucracies are implicated here. Notably, he says that they do not have standing because DAPA will cause an influx of illegal immigrants that will somehow cause economic harm. And indeed, I think the Washington state, on behalf of some states supporting the government, cited a Cato study or blog post or report talking about how, for example, the DREAM Act that was the precursor to DAPA didn't cause, the Executive DREAM Act, the DACA, didn't cause the surge in unaccompanied minors from last summer. So Cato, even though we take this legal position, we fully agree that illegal immigrants, including those who would benefit from DAPA, would probably be a net economic benefit to the country, even as they cause these certain types of costs to these states. Anyway, so that's on standing. And the rest of the opinion focuses on the APA, the Administrative Procedure Act, ultimately finding that the Homeland Security didn't go through the proper notice and comment rulemaking procedures. That, by the way, is how Chief Justice John Roberts could end up ruling on this. Very narrowly, you could get a unanimous or nearly so opinion from the Supreme Court saying, whatever it is with this, however much discretion was given, whatever the constitutional issues are, which Judge Hannon also didn't reach, Obama administration, why don't you go and try to proceed through the APA? That runs out the clock a little bit more, potentially through the end of the administration, depending on how cheeky they want to be in their notice and comment hearings. But to reach these conclusions, the court found that Congress didn't delegate sufficient discretionary authority to implement such broad-based deferred action. And I remind you that even in individual cases, deferred action isn't explicitly authorized by statute. And he rejected the presumption of unreviewability under Heckler versus Cheney that was mentioned because DAPA represents a complete abdication of the government's duty to enforce the laws as written, and indeed is an affirmative action in contravention to the laws. Judge Hannon stressed how important it was to preserve the status quo, because once granted, the expanded DACA or DAPA will be very hard to reverse and its benefits exceedingly difficult to claw back. It would be a public policy nightmare, whereas on the other side, there's no urgency. The government isn't harmed by postponing or delaying its policy until it can be fully reviewed by the courts. And I agree with all of those points. So what can we expect in the future? The government apparently doesn't know what it's going to do. I would have expected, certainly, I read the transcript. The government was there. I just read the transcript. The government was actually at the hearing. Based on the hearing, I think there was no surprise what actually came out with the opinion. We knew it was going to come in the last week or two. I would have expected them to file an emergency motion for stay, an emergency expedited appeal to the Fifth Circuit simultaneously to the Supreme Court, something like that. And yet, we're still 3 days later and we haven't heard from them. Did they really? Is this hubris? They thought they would win nevertheless? I don't know. I don't think there'll be an emergency stay because staying the temporary injunction effectively gets rid of the need for a temporary injunction. At that point, the government just wins. But I think we might have expedited briefing and argument before the Fifth Circuit. Some people are saying this could be added to the Supreme Court's docket in time for a ruling this term by June. I think that's a little optimistic or pessimistic, depending on your perspective. I think the court will set it for briefing over the summer with argument perhaps in a special session in September, as happened with Citizens United's re-argument 5-6 years ago, with an opinion probably by the end of the year. I think that's kind of a realistic standard on this. And I have little doubt that the Fifth Circuit will affirm the lower court judge, just kind of doing a little bit of legal realism. Regal legalism is what Obama's doing. Because this is the most conservative Republican-dominated court in the country. It's 10-5 Republican to Democratic nominees, including the judge I clerked for, I must say, Grady Jolly. So the ultimate result here is anybody's guess, but given that I filed a brief on behalf of supporters of reform, I certainly do hope that the final ruling mirrors Judge Hannon's scholarly work. And at the end of the day, I'm just saddened by this whole episode because, as I said, it hurts the cause of real reform, which this country sorely needs. First, because the people with a temporary legal status aren't really coming out of the shadows, or if they are, they're coming out of the shadows, but still under a legal cloud, to continue the metaphor. Their monetary benefits certainly won't be clawed back in the future, but their residence permits and so forth don't necessarily have to be renewed. And finally, we've all heard about how Obama's poisoned the well. I think that's absolutely true. If he'd spent a 10th or even a 20th of the political capital on trying to get legislation through Congress rather than keeping the issue simmering for electoral advantage that President Bush did, I think we would have gotten somewhere. As it stands now, this now goes to the next president. Perhaps it's an opportunity for a Nixon to China moment, for a President Cruz to implement immigration reform with Congress. But these policy arguments that Kamal makes are just, well, maybe they're heartening in some sense to the extent that this is an economic benefit to the country. Well, I then look forward to joining Kamal in praising President Rand Paul for suspending the corporate income tax and praising President Scott Walker for suspending the National Labor Relations Act. And the country will be much better economically off if presidents get such discretion. In the meantime, immigration activists are doing themselves no favors by claiming that an obvious violation of both administrative law and the separation of powers helps those who need real reform. Thank you.
All right, so do you guys have any other comments, or would you like to go right into questions? All right, Kamal.
So if I can, I guess I'll go first. I'm outnumbered here. A comment's been made multiple times that this isn't really prosecutorial discretion. In fact, Ilya, joked that this is like your local prosecutor putting out a bulletin board saying who he's going to prosecute and who he's not. So I want to talk about a couple of things. One, why this is not that. Why this is not your local prosecutor putting out this, non-prosecution bulletin board. Two, I want to talk about why this is, in fact, prosecutorial discretion. In theory, I want to touch a little bit about this work permit question that's been mentioned a couple times. One, this is nothing about this is perspective, right? The door on who's eligible for this closed on January 1st, 2010. In order to be eligible under this program, you have to be in the U.S. since January 1st, 2010, and you have to have a U.S. citizen child as of November 20th, 2014. So this is not a prospective category that's protected. This is a category that when the president made the announcement on November 20th, the door had already closed in terms of getting into this category. Two, why is this prosecutorial discretion? I mean, I think that's a good question. When we think of prosecutorial discretion, we think of a cop stopping an individual and then exercising discretion to let them go, right? Sort of a defensive, event, right? You're being prosecuted, or you're already the subject of prosecution, or you're a target for investigation, and then prosecution stops for whatever reason. So this is prosecutorial discretion because at the end of the day, you're getting the same that you would be in that situation. You're getting a designation called deferred action. You're not getting a status. You're able to apply for a work permit, and I'll talk about that in a second, but you're not getting a status that entitles you to be in the United States. You're not entitled to a process as part of that application process. You're not entitled to an appeal. You're not entitled to any kind of review. If you don't like the decision that's made, you just have to pay the fee again and apply all over again. This is truly discretionary. I appreciate David's point that the rejection rate has been low, but I would make a few observations about that. One, applicants understand that this is discretionary. So the pool that's actually applying, and I've met with these individuals, I've helped some of them apply, is a self-selected pool. People who understand that there's something derogatory in their record, or there's anything that would not justify a favorable exercise of discretion, are not going to apply, because if they come forward and apply and they're rejected, they make themselves vulnerable to deportation. So that's one. So we would expect, just given that, you would expect that the rejection rate would be low. Second, even though the rejection rate or the denial rate is low, people who get deferred action have lost it since because of encounters with law enforcement. Hundreds of people have had their deferred action rescinded without any process, without any notice, generally. And we've spoken to these people. They've called us. So we know these situations exist. Third, I just want to talk a little bit about this work permit question. If you're exercising prosecutorial discretion, if you're the cop who's letting the individual go, then why are you giving them a work permit? Why are you giving a work permit at the end of this? And the reason is this specific form of prosecutorial discretion deferred action, because of both statutes and regs, and I'll lay them out in a second, comes with permission to apply for work authorization. In 1986, Congress gave the executive permission to designate classes of individuals who are authorized to work in the United States. Here, Attorney General, you tell us who should be allowed to get a work permit. In 1990, regulations issued under Republican administration implementing that statute laid out a list of categories who would be eligible for work authorization. And part of that list is people who get deferred action. There are other individuals who don't have lawful status who are also eligible for work authorization. For example, people with pending green card applications, even if they're not lawfully here. People who are applying for certain kinds of relief, like cancellation removal. So people who are not eligible, who do not have a status in the United States, there are tons of categories of those individuals who can nonetheless apply for a work permit. A work permit is not status. Thank you.
A couple of things. Let the record show that even Kamal agrees that a category of individuals eligible for this particular form of relief has been created by the president. I don't understand why the fact that this category is semi-capacious and not infinitely capacious, and that it's not prospective, and that some people who do not qualify under the three criteria set forward changes, ladies and gentlemen, the fundamental conclusion, inescapable conclusion, that a category of individuals has been created who would not be prosecuted under INA. That is par excellence example of suspending power. If it's not suspending power, then suspending power has no meaning, because you are excusing from application of law on a categorical basis some subset of a people, not on a case-by-case basis. Again, I don't care if it's this wide or this wide. It is still a category of people. Point number one. The thing that bothers me, frankly, Kamal, with respect, is the second point about the fact that, yes, enforcement discretion never, ever entails anything but the decision not to prosecute. And I agree with his cop analogy. My analogy, which if I had more time I would have mentioned in my presentation, if IRS decides not to prosecute you for cheating on their taxes, they may not put you in prison, maybe even waive penalty, but they don't send you a bloody check. They don't give you any boons. They don't give you any benefits. Look carefully at the statutory language. It is true that work authorization attaches in situations where, pursuant to some specific statutory authorization or the true exercise of enforcement discretion, prosecutorial discretion that is, ICE officials, or before that INS officials, first decide to come up with some form of relief, statutorily authorized, and then you may get work authorization. What it does not mean, ladies and gentlemen, that having created entirely brand new categories of individuals for the form of relief of deferred action that does not exist in the statute, then you can go and attach to that category work authorization. And by the way, they're not just getting work authorization, they're getting work authorizations, they're getting Social Security numbers, there's discussion of be getting Medicaid and Medicare benefits and Social Security benefits. This is utterly unconstitutional. If that is constitutional, there's nothing that the president can do. And I agree with Ilya, you can have wholesale waivers of many laws, which I personally disagree just as much as passionate immigration advocates disagree with INA. There's a lot of bad things in Clean Air Act and Clean Water Act and NLRA, National Labor Relations Act, and many other incrustations of administrative state. I can come up easy peasy with some, with some better solution. How would environmentalists like if an ex-president did that? Or you can rewrite the tax code. You can write your own tax code, okay? Call it prosecutorial discretion. So instead of having people pay the statutory rate on ordinary income or cap gains, you can just say, exercise of prosecutorial discretion. If you pay half of that, that's fine with me. And you could put it in a memo. And you can call an exercise of enforcement discretion. It is utterly unconstitutional. It warps the separation of powers. It sets a horrible precedent. And I don't want to get into whether or not it's good immigration policy, because with respect, those things matter more than any given policy exercise. And one final point, I cannot help myself, because FPP has been mentioned several times. Words do matter, ladies and gentlemen. The FPP was solidly grounded in the existing voluntary departure statute, which is not the same as deferred action. And I quote, "The Attorney General may in his discretion permit any aliens under deportation proceedings to depart voluntarily from the United States at his own expense in lieu of deportation." That is called voluntary departure. What the president is doing is not voluntary departure. He calls it deferred action, and they're not the same thing. And if they're the same things, then words mean nothing. And we're in Alice in Wonderland type situation. Thank you.
All right. Well, Ilya, do you have any comments?
Let's just get to the questions.
All right. So we have microphones going around, so please raise your hand if you have a question. Right up here up front.
John Fury, Center for Immigration Studies. Mr. Essaheb, you mentioned a moment ago that when President Obama announced his program, that the door was closed, only certain people would be able to qualify. But isn't it true that when President Obama first announced his deferred action program, there was a date cutoff, which I think was 2007, there was an age cutoff, which was, I think, 31, but in his recent announcement, he also changed that. He changed it to 2010. He got rid of the upper age cutoff, I believe. So what would stop a president, or President Obama himself, from further expanding these categories down the road?
Well, we as advocates will push him to do that. I mean, we would want that to happen. No, it's not a joke. It's not a joke. We would, no, but as announced, the categories as announced, the criteria as announced on November 28, 2014, are not in themselves an announcement. They're not in themselves an invitation for further illegal immigration. So that, I mean, that's the view we would take on that.
Can I just forgive me for, under your logic, Kamal, if you're not exercising suspending power, which is a total suspension of a law, anything short of that, which is called dispensing power, is kosher. But it's not true. They're both equally unconstitutional. So who cares how broad the category is?
One last critical thing. You mentioned the claim that the United States spends more on law enforcement than other immigration law enforcement than other law enforcement combined. That's from a Migration Policy Institute report. The problem with that report, though, is that it combines the budgets of ICE and CBP together to come to their number. And unfortunately, the C in ICE and CBP stands for customs, which has nothing to do with immigration enforcement. I encourage you to take a closer look at that report.
We'll take a look at it, but either way you cut it, if you look at it from a longitudinal perspective, over time, those numbers have gone up over the past decades.
All right. Any other questions? Right here, Ian.
Thank you. Kamal, you mentioned that the CFR permits the issuance of EADs, work authorizations, to deferred action recipients. I just want to point out that John Eastman, a professor at Chapman University, in the latest issue of Engage, FedSoc magazine.
Yep, and that article's actually outside. So
It's superb, and it eviscerates Kamal's argument there. But my question was to Ilya or Mr. Rivkin. They say that there's claims that DACA and DAPA have stretched the resources of USCIS to the point where legal applicants are getting their applications, for lack of a better term, deferred. that process is being elongated. So I'm wondering if those legal applicants could get standing, perhaps, to challenge DACA or DAPA.
It's possible. Yeah, I guess they're harmed. I mean, the thing is that this Texas suit is so far along that, you know, why spend the resources and time and raise your head in the system to, you know, needlessly, or I guess they could intervene in this, but at this point we're too far along. That would have been a theoretical consideration right away, I suppose. And it's still bizarre to me that would happen, given that DHS has been hiring like gangbusters, and that's actually while the government, to its credit, and this is how low we've sunk, that we have to point out, you have to applaud them for actually following what the court is doing and stop not pursuing the applications and processing and whatnot. But DHS is still, as far as I know, preparing for and, you know, leasing office space and having the workers and things like that. So I hope that whatever happens, that you know, legal applicants aren't harmed, whether because this is stopped finally or because the administration gets its act together, and the people that had USCIS officers that had been handling the, you know, normal course keep handling the normal course, and only new hires handle the DAPA.
I spend most of my waking hours trying to come up with clever ways for folks to gain standing to challenge what this vet agency is doing and get paid for it in the process. So it's all good. I doubt it. The two questions always are, is clearly they suffered harm, but it has to be legally cognizable harm. Now, in the case of states, of course, it is legally cognizable harm because as sovereigns, they are forced to spend money on driver's licenses, or I frankly like my more highfalutin arguments about improper preemption of state police power, which, by the way, is in play. The judge referred to it as abdication standing of some favor. It's not what he is hanging his head on. But here, you basically would have to argue that the agency is acting arbitrarily and capriciously, it would be an administrative law label, because they're siphoning off too many resources doing something unlawful, and therefore they cannot discharge their lawful functions. Unfortunately, all lawsuits dealing with prioritization of government resources have been unavailing. It's like saying, if you, for example, New York City would be a good example, if you enroll all the police officers in new sensitivity training to ensure that they don't do stop and frisk or various other unpleasant things, and they're doing it 90% of their time instead of being on patrol, when you got mugged, because of this idiotic policy, inadequate resources were spent to deal with muggers. Very unlikely, because again, and you know, standing is important. It's the gateway into Article 3.
Can I just address the work permit question, because I think it's important, and I look forward to reading Professor Eastman's article. Part of the rationale for these various categories are people who are not in lawful status, but who are nonetheless authorized to work, is that the government has somehow acquiesced to their presence in the United States. Now, we have a situation where we have 11 million people in the United States who are here without permission. Nobody, at least I haven't heard that on this panel, is suggesting that we deport every single individual. You know, we are at a max level of resources in terms of how much we're committing to immigration enforcement, and we are deporting approximately 400,000 individuals a year, less than 4% of that population. Nobody's suggesting that we spend trillions of dollars to achieve 100% enforcement. So these categories of people who are authorized to work reflect that acquiescence. We're not going to deport 100% of the individuals. Then individuals who fall into some categories, like people with pending pending green card applications, people who with pending cancellation of removal applications, and other categories, people with deferred action, those people should get a work permit in acknowledgement of the fact that we are not going to deport them.
Nothing reflects more, and sorry to cut in, the disagreement between Kamal and this discussion. Again, to clarify, to repeat, in the past, you had congressionally created Article 1, Article 2 came together and created buckets of administrative discretion. And if you're in one of those buckets, one of those pathways, Congress also said you can get work authorization. That has nothing to do with you first creating an entirely out of thin cloth, or no cloth, your own category, and then legalese is called bootstrapping, which, by the way, for somebody in district court or appellate court asks you about bootstrapping, that's not meant as a compliment. You're bootstrapping this. This is not how it's supposed to work. And the fact that you're giving people boons per se undermines the notion that this is enforcement discretion or prosecutorial discretion, because again, the cop who stops you for speeding does not give you $5. At most, he would not, as I think Kamal said, he would let you go. IRS, if he catches you cheating in taxes, does not send you a refund for that.
So on this category question, the categories that were laid out by the president are categories of people who could apply, not categories of people who get the benefit. It's still a discretionary adjudication process to determine who actually gets it and who doesn't. And why does that matter? So currently, you could apply for deferred action as an immigrant. You could apply, you would send a letter to your district office and you could say, here are my equities, you wouldn't pay a fee, you would send a letter, here are my equities, I've been here for 30 years, I have this number of US citizen children, give me deferred action. There is, and hundreds, if not thousands, of such requests are granted every year. There is regional disparity in how those applications are adjudicated. There's not transparency in how that's done. And there is discrimination in how that process is conducted. Now, if you have guidelines as to who could apply for that deferred action, we think that's exactly the kind of transparency you need in exercising discretion. So the categories are not who ultimately gets the benefit at the end of the day. The categories define the class of people who get to apply. They have to jump through those hurdles first, and then they additionally have to show they merit discretion.
In the back here.
Leaving aside the sophistry of OLC in both the Noel canning and this attempt to justify this, this is a question for Kamal. What is the limiting factor? And I expect either a U.S. Court of Appeals or the U.S. Supreme Court will ask that question at some point, should that be teed up for him, with regards to what the president could do in this instance with regards to deferred action. For example, could he announce that he's deferring action for everyone who donated to his campaign? What limits?
So I'm not an expert on, I do immigration law. So I don't do environmental law. I don't do campaign finance. So I can't really speak to the intersection of those bodies of laws. I mean, in terms of, we are going to continue to push for the broadest. I mean, I'm being transparent about that, for the broadest category possible. I mean, what the limiting principle is. I mean, obviously, they can't do something that entails that they won't spend all the resources that Congress commits to immigration reform. They can't do that. They can't discriminate based on improper bases. They can't say, well, we're not going to deport people from Mexico, but we're going to deport people from Eastern Europe. So there are other limiting principles out there, but I don't think the numbers themselves, if this is what you're getting at, I don't think the numbers themselves define the limiting principle.
Can I take a stab at this? This is a very important point, and I don't do immigration law, but I do constitutional law. The courts often in cases, and this is not, I mean, this is, you can do it on the statutory grounds, but if you reach constitutional grounds, there has to be limiting principles. Remember Verrilli's inability to explain another lawsuit, galaxy far, far away, called NFIB, in which I was involved.
Or was that a strategic inability?
Or, well, no, there's no answer. There's no answer. As you know, Ilya, I argued this case at the district court level, and same thing. It was not Verrilli, but it was a very able deputy in the civil division. If you can do that, if Commerce Clause is eminently capacious, then you swap any notion of limited and normative powers in Article 1, and the federalism is destroyed. Here, we're talking about horizontal separation of power primarily, but also with the vertical separation of power impact. If a president can come up with unlimited categories justified only by some policy raison d'etre, in this area, you can do the same in environmental law, you can do the same in worker safety law. There's no limiting principle. So what? And I mean, maybe the notion about, if you gave money to me, Kamal was right. You could bootstrap it with a Bill of Rights. But aside from the Bill of Rights, there's no judicially, the magic word says, no judicially enforceable, meaningful limiting principle. You can do it for 4 million, you can do it for 11 million. And if you look at the universe of people who violate Clean Water Act, you can do it for, a couple million of businesses, because Clean Water Act, not to waste of time, doesn't make much sense at all. It doesn't give you clean water, it costs money. You can go for entire alphabet soup of every agency in this town and every statute in the book and just dispense with, rewrite it by executive fiat. It would totally castrate Article 1, and it would totally change the kind of republic we'll live in. I don't understand how it can be a good thing, no matter how passionately you feel about this particular cause. Because this country is about processes and procedures, first and foremost, and not about policy outcomes, because we'll never agree about policy outcomes. And you certainly cannot have courts adjudicating the merits of policy outcomes. That is non-reviewable discretion indeed.
A small technical footnote before Kamal responds, if he wants to respond to that. On the, how broad, or, the OLC memo says that the parents of citizens who I described normally under the way the law is written have a very long time to wait until their child is 21 and then have to leave the country for 10 years and all that. And there's no provision like that for lawful permanent residents at all. LPRs, green card holders, cannot sponsor their parents. But the justification is that these people are eventually eligible for status, even if it's they have to turn 21, but they're eventually eligible. Therefore, you're providing this bridge. How can I say you're not providing a bridge? You're providing a bridge between statuses, or to a lawful status. It's actually more likely that everyone in the country would then eventually be eligible, because it takes a lot less time, energy, and resources to fall in love and marry a citizen than it is to wait for your kid to turn 21, wait 10, I'm not talking about sham marriages. I'm talking about actual, people who are not in the country illegally who marry citizens. And so that means that's, a category that's almost everyone, or everyone that's not already married, although I suppose they could get divorced and whatnot.
All right, one final question. Ramon?
Well, I understand that you're here and your organization favors this immigration policy, and that's what your job is to do here. But as a citizen of the country, and
First of all, I'm not a citizen of the country.
oh, okay, all right. So as a permanent legal, or as a legal resident of the country who has a stake in what goes on here, does it trouble you that does David Rivkin's argument that the president would have unfettered power trouble you? And if it troubles you as an American, or as an American resident, where do you think the line should be that limits the president's discretion in the enforcement of laws?
Well, when I answered the prior question and said, well, I'm not an expert in these other bodies of laws, it's because I'm not, and I don't know what the statutes say. I don't know what the precedent is. I don't know the extent to which those agencies, for example, have discretion to do X, Y, or Z. I can speak about immigration. So in immigration, I'm fully comfortable that what the president did is legal. And as an attorney, I feel comfortable that it's legal, and everything that I set up there, I totally believe. So none of this troubles me. I appreciate David's argument. I just don't agree with it.
All right. Well, thank you everyone for coming. Let's give our panel a round of applause.